Oh, hey, friends. It's Josh and Dodger. Dodger. We're out looking for squirrels and thinking about trust and estates matters. Today, we're going to spend a little time thinking about the amendment or restatement of trusts. So, Mom and Dad wrote a trust in 2005, let's say. And they were young and beautiful at the time. They didn't have any kids, or maybe they had one kid and they had an estate, whatever it was worth. They wrote an estate plan. But now things have changed. We're 20 years later and stuff changes. We know more about the kids. There might be grandkids. The net worth may have gone up a lot. The successor trustee, who was Dad's brother, might be dead and or living in another part of the country and not appropriate. So stuff changes, right? Estate plans change. So the family goes into the drafting attorney's office and find with some consternation that the smart attorney that the family used for years is now an old man. But Mom and Dad are now old people too, so things happen. And the question is, what do we do about these few changes? Mom and Dad know the changes they want. They want to provide some money for the grandkids' college. They want to change the successor trustee from Uncle Eddie to one of the boys that happens to be an accountant. They want to change some of the specific bequests, the gifts to the local church or Boys and Girls Club or whatever. They know what they want. The attorney says, well, we're going to do a restatement versus an amendment. What's the difference? A restatement is we tear up the old document. First page to last page, doesn't exist. And we start over with new words. And we write a whole new document. The alternative is an amendment where we say, look, the current document's fine. Yeah, we need to change a couple of sentences or a couple of words, add a new paragraph around the kids' college. Hey, Dodger. Our grandkids' college money. Change the name of who the successor trustee is, but we don't need to start all over and go again. So, which is better? And like you would expect from any mealy-mouthed attorney, my answer is it depends. And I'll kind of outline for you why my colleagues tend to say a restatement's better. They tend to say a restatement's better because the laws may have changed, and the laws written in the 2005 document, the words written in the 2005 document may refer to laws that are no longer laws or have been changed themselves, and we want to integrate those new laws. Maybe drafting best practices have changed, where once it was common to use a bypass trust or the B trust. Now it's more common to let the surviving spouse disclaim into a trust. So there are systemic things that have changed. They say, look, we should just start from the top and rewrite this dang thing. Another reason they say we should start from the top and rewrite is if you had your documents written by a different attorney, this new attorney does not want to be bound by the words and organization and approach that the differing attorney used, even though we concede they had the same bar license, even though we concede they're probably good trust and estates attorneys. We are creatures of habit. We're familiar with our own stuff. And where's my dog, by the way? I'm going to go back and find him. We prefer our words to theirs words. Well, sometimes my colleagues say there's too much risk to use somebody else's primary document. I'd rather just start from scratch. Ah, here he is. Good boy. Another reason, to be frank, is amending documents sometimes takes longer than restating them. Why is that? Well, some pretty sophisticated software has been built for attorneys for drafting documents. Really cool databases. There's probably 6 companies out there that have developed the templated documents that all of us use. None of us sit down with a typewriter and start writing on a blank piece of paper. We're always starting with a standardized document set that we bought from somebody. a system, a database. And drafting those documents is actually a pretty technologically quick and efficient way of getting an outcome. And sitting down with a blank piece of paper, which is what is required when doing an amendment to a trust, particularly if there are multiple amendments. Let's say there's 3 things we want to change. It's possible that writing a 3 or 4 page amendment to an existing trust takes longer, more hours for the attorney than just a full restatement, because the full restatement has the database and it's memorized all the key terms and the way the attorney likes to write it. Put in the names and press the button, integrate, have a new doc. So those are the reasons that my colleagues tend to prefer restatements to amendments. So what do you prefer, Josh? Well, being an obstructionist cuss, I prefer amendments. I tend to do the opposite. You can ask my mom. It's always been that way. I think with the incredible new power of AI, we can read old documents quickly. So we don't have the problem of becoming familiar with somebody else's document. So that objection for me is not a huge one. It's easy for me to look at the documents from some other attorney that wrote this thing in 2005 and determine, are there clauses in here that are legacy clauses because the law have changed? Are there clauses in here or organization of the document that are no longer best practices? They work fine, but they're not best practices. That's easy to identify and integrate with AI, because these AI tools can read that document in about 1/10 of a second, where it might take me an hour or more with the yellow pad writing notes. Writing the amendments, I think writing the amendments takes, an hour on the outside. Just like all things in trust and estates practice, it ends up being a boilerplate thing. The amendments are always the same. We want to change the successor trustee. We want to set up a trust so that one of our kids who's had a problem with addiction doesn't get their full inheritance all at once. We want to provide for the grandkids. So those fact patterns come up over and over and over. And once a library of amendments has been created, it's pretty simple. So that's my preference, personal preference. Again, reasonable minds can differ. I don't quarrel at all with my colleagues that prefer to do restatements. I understand deeply why they prefer to do them, and believe that their conclusion is reached in good faith. I just don't choose to do it that way. So that's all we got from Josh and Dodger, the not squirrel catcher. Dodger, let's go. Talking about riveting subjects that about 15 people in the state are interested in. Ciao.